Good morning. If we could get started, please. Good morning, everyone. Good morning and welcome to day 3 of our program. It's my pleasure to welcome each and every one of you here today. I'm Mike Walker from the Environmental Protection Agency in Washington, D.C., where I'm the director of the National Enforcement Training Institute. Our program today, this morning, is improving the effectiveness of environmental law. And we have an outstanding and very distinguished panel here, beginning on my right, Professor Elizabeth Kirk from the University of Dundee in Scotland. On her right is Professor Joel Mintz from Nova, Florida. On his right is Steve Wolfson, my colleague at the Environmental Protection Agency. On his right is Alex Wang, professor at the University of California, Berkeley. And finally, bringing up the very end, Professor Lee Paddock, my colleague from the George Washington University School of Law. So welcome, everyone. Welcome, panelists. We're going to begin with Professor Elizabeth Kirk, who is a senior lecturer at the University of Dundee School of Law in Scotland. She has been focused on adaptability within legal regimes, in particular the ability of legal regimes to respond to changing circumstances. And if any of you had the opportunity to see the Washington Post this morning, the most recent poll is that the public has grown tired of climate change. They don't believe it, so we have quite a road ahead of us. So please welcome Professor Kirk and her changing regimes.
Well, thank you, Mike, for that introduction. And could I first of all thank the organisers for this fantastic conference and for this opportunity to present the research that my colleague Alison Reeves and I have been doing. I'd also like to thank the Society of Legal Scholars in the UK, which has been supporting our work. So what I'm talking about today is about ways in which we might help regulatory agencies to adapt to the changing demands that they face at times. So perhaps I should start by explaining or giving examples of the sorts of changes that regulatory agencies face and why we think that they might need some help at some point. So I think I'm sure we're all aware of the various stages that different regulatory regimes go through and agencies have to face where, in the UK, and I'm going to be talking largely about changes and developments in UK law in my presentation today, but I hope that they'll be illustrative of changes and developments elsewhere. But, we've seen the regulation change from focusing on end of pipe, where the regulators are basically required to monitor what's coming out of the smokestacks out of pipes going into waterways, to adopting managerial processes where they have to start addressing and managing the actual processes that take place within industrial factories and so on, to now, more recently, the adoption of holistic approaches where the regulatory agencies are faced with having to now not just look at what's happening within an agency, within an organisation, but also looking at the physical environment and how we interact with it, and also the economic and social uses that we make of it and the values that we place on it. Now, each of these changes represents what we might call a punctuation point. It's a point at which we might anticipate that if the agency is to adapt, it will have to adopt new internal norms of behaviour and new procedures. And in work that Alison and I did a while ago, we were focusing on the Scottish Environment Protection Agency. We found that the agency had a lot of goodwill, as you would expect. I mean, it's staffed by people who are passionate about the environment. But when it came to changing, and we were looking at its ability to adopt a holistic approach in response to the introduction of the Water Framework Directive, what we found was that the agency struggled to change because it lacked human resources and the financial resources to change. We found that the agency had about 95% of its staff had a physical science background. So when it was being asked to take account of economic and social issues, it simply didn't have the capacity. And like any environmental agency, it didn't have the money to throw at the problem to basically employ new staff. And of course, that's an issue that has intensified. We looked at the Scottish Environment Protection Agency before the economic crash, and of course, financial constraints have got a lot tighter since then. So what we wanted to do was to find a way to help SEPA, the Scottish Environment Protection Agency, and other agencies to adapt to change. And so what we did to begin with was we started looking at existing legislative devices. And of course, there are a range of devices that are already used. The sorts of obligations, for example, to consider particular types of information. So I've given you an example here which requires the English Environment Agency to look at the effect on water quality of potentially polluting activities. So these types of obligations could, of course, be tweaked, and they are being tweaked. You also have obligations to give reasons for decisions, and again, that might prove useful. But both of these suffer from a basic defect in that they don't really promote capacity building, and what we're looking at is capacity building. They just really, if anything, hold the regulators to account. So we also have other types of processes, the various review processes, appeals and judicial review. Again, they involve a review of what's happening within the environment agencies, but they don't, again, do anything for capacity building. We do have one set of processes that are embedded in some regulatory regimes, the adaptive management processes, which, as I'm sure you know, they're iterative processes. The regulators implement their new process, they review how it works, they look to see whether any adaptation is needed. And that's being used quite extensively in the European Union. I understand, and this is the only thing I'm going to say about the US, that it is also used under the National Environment Policy Act. But as, again, review is only going to be as good as the people that are undertaking it. And so if you have an agency that is still staffed by primarily physical scientists, there may still be things that they overlook. So we looked for another device. And again, we found another one that's used. As we know, public participation is used as a way of enhancing capacity to help solve problems. And so it can work by bringing in new expertise and ideas, so it has the potential to perhaps give the agencies the support that they need. It can help if you have a particularly strong group within an agency that is resisting change. Then by bringing in more actors, you can change the balance of power, you can change the power dynamics, and so that may help with pushing forward and supporting the norm entrepreneurs within an agency who are pushing for development and change in how they work. But each of these, again, face some problems. At times, the public doesn't bring in new ideas. The public represents the entrenched view, and the see if it'll come up. The classic example in the UK at the present is there is an attempt to have more wind farms put in place so that we can move to more renewable forms of energy production. But the problem is that the local population often object to the wind farms, basically because they don't like the look of it or they think it's going to be noisy. So they represent the entrenched view. So that brings you back to the same problem. You need more new ideas. There can also be a problem in that sometimes the way the legislation is framed does not allow for the full introduction of new voices. So, again, I'll give you an example from the environmental permitting regulations in England and Wales. These provide that when the Environment Agency is considering whether to grant a permit for a potentially polluting activity, that it should consult with any communities that may be affected by the development. Now that's actually quite a narrow, or potentially a very narrow definition of who should be consulted with. And in Scotland, the equivalent regulations are a bit wider. They basically provide that anybody who is interested can comment on the permitting applications. So these public participation in that sense doesn't necessarily help with these problems. There's also some further problems, and that is, again, we found with some research that I did with another colleague, Kirsty Blackstock, who's in what is now known as the James Hutton Institute. We were looking at implementation of public participation, and we found again that often those that are tasked with introducing or using public participation do not have a background in its use, and so they're not aware of best practice. And so they perhaps hold meetings at times that aren't convenient. They hold them during 9 to 5 office hours when people cannot be present. They may convey information in a way that's understandable to scientists, for example, but not necessarily to the general public, or they put the information somewhere that's not particularly accessible, so perhaps the public have to go to an office to find the information. And that can be, in the more rural parts of Scotland, particularly problematic. And again, because the people that are actually conducting the participation may not be experts, or may be experts in a particular area, they may not notice some information that's relevant. They may not realise that some of the information that they're being presented with is relevant. So there are some problems with these mechanisms, or with relying on these mechanisms as ways to help agencies change. So we wanted to then look for something different. And what we turned to was what's known as participatory action research. It's quite similar to the adaptive management processes that are already used. The key difference is that a friendly outsider is engaged in the review process, and the friendly outsider, basically their job is to look for good practice, and to look for blockages, and find ways of advising then the agency to adapt, or whoever it is that they're working with to adapt, and work with them on adaptation. Now, participatory action research has been used already in some areas, but the practice so far has revealed a few potential problems for its use to help agencies to adapt to change. The first problem, or maybe both of them, can be summarised by the divergence in participant and researcher expectations. But the primary problem is that where participatory action research has been used, it's been used at the behest of the researchers and not of the regulators. Excuse me. And so the research then follows the researchers, or the funding authorities, timescales. And that means it may be designed to answer a particular question, or to look at a particular question. It may not follow the legislative process all the way through. And it may be that those who are involved in or working within the regulators believe that certain important issues have been overlooked because perhaps they weren't encapsulated in the research question, or because the research finished by their perception too soon. I've referred to an article by Collins, Ison and Blackmore here, and what they found in their work, they were looking at using participatory action research to help the environment agencies and those that were involved to develop a model of river basin management planning following the introduction of the Water Framework Directive. And again, what they found was that while the researchers thought the process had been a success, those involved in the day-to-day operation of the river basin management plans were disappointed, because at the end of the process, no model river basin management plan was produced. So they felt disappointed. The researchers believed it was a success because they could see that those involved had learned how to start developing their model. Okay, so there are some potential problems. So what we suggest is that we should adopt a modified participatory action research. And how the ways in which we would modify it are as follows. First of all, we would actually embed PAR within the regulatory process. So it would be a recognised part of it, but we realise that, first of all, it might be unwieldy to embed it in all regulatory processes, and secondly, given the financial constraints that we face, that's just not going to happen. There's no way that we would find the funding for that. So what we suggest is that PAR should be embedded in the transition stages. So when new legislation is adopted, that at that point we start to use participatory action research, and we also suggest that it should be used particularly to focus on capacity building, and it should be used in conjunction with tools that we already have. And so for that reason, we suggest it should be linked to participatory processes already. So where we already have provision, or where the legislation would involve participation by the public, we, as a first stage, adopt participatory action research there to help the regulators to adapt. Now, that might be a recommendation that is particularly apposite to the United Kingdom. It may be that in other countries, if there's been more experience of using participatory action research, that, public participation, that another point would be the best place to embed the regulation or the participatory action research. So, finally, and maybe this will make Mike happy to know that I'm on to my last slide. What's our way forward? Well, what Alison and I plan to do is to develop a research proposal. We're building on the article I've put on the overhead, and we would like to call on you to see if anybody is interested in collaborating with us. So we'd be particularly interested in hearing from anyone who has been involved in this type of research already, but equally hearing from others who are interested in becoming involved. And we also hope to produce an edited book, ideally focusing on participatory action research, but we'd also be interested in bringing in discussion of adaptive management processes where they're used. So if you would like to be involved, or if you do have any information about research that's already been done, please do talk to me during the colloquium, or contact us, and you can contact me on this email on the overhead. So can I just thank you all again for your attention, and I'll be happy to receive any questions later. Thank you.
Thank you very much, Professor. Professor Kirk, as I mentioned, is from Scotland, and she has been existing here in the heat with some difficulties. So thank you for being here. Our next speaker this morning on the effectiveness of environmental law is Professor Joel Mintz from Nova Southeastern University Law Center in Fort Lauderdale, Florida, where he teaches environmental law, environmental enforcement, and torts, and we hope you have toxic torts on there as well. Among his many achievements have been a number of books, one of them in particular, Enforcement at EPA, Hard Stakes and Hard Choices. Another one of his achievements, and I hope it's an achievement, is that a number of years ago, Joel Mintz hired me to work at the EPA, and it was at a time when the economy was not doing so well. There was a war in the Middle East, there was gas rationing, there were all sorts of federal hiring freezes, and he said to me, you can work for EPA permanent part-time, 39 hours a week, and if no benefits, and if someone leaves, retires, or dies, you'll have his job. And in fact, someone did die within 3 months, and that's how I began my career at the EPA. So please welcome Professor Joel Mintz.
Well, I am the one to blame for hiring Mike Walker, and it is an achievement I'm very happy with, actually. Mike's done a wonderful job at EPA, truly. And thank you for that kind introduction. Thanks also to Bob Percival and Suzanne Langrel and Bill Permatai, and really to everyone who worked so hard to put together this excellent conference. My presentation this morning is titled Lessons from the U.S. Experience with Environmental Protection. I'll begin with a sort of a brief overview of some areas in which U.S. enforcement has succeeded well and some of the circumstances in which it has fallen short. I'll then refer to 9 conditions whose presence, I think, is needed for government environmental enforcement to succeed fully as a mechanism for environmental protection. Finally, I'll assess the extent to which U.S. enforcement of pollution control requirements at the national level has or has not satisfied those conditions. Because my time is quite limited, I plan to focus on the enforcement activities of the U.S. Environmental Protection Agency, or EPA, which is the federal agency with primary responsibility for enforcing U.S. pollution control laws. Regrettably, notwithstanding their significance, I will not have time to examine enforcement of environmental laws by private citizens, nor will I discuss the enforcement work of other federal agencies or departments or of U.S. state and local governments. Most of my conclusions today will be based on findings of my research into the historical evolution of EPA enforcement, a primary scholarly interest of mine since 1983. I've published 3 books and numerous book chapters and law review articles that touch on that topic. My most recent relevant book is Enforcement at the EPA, High Stakes and Hard Choices, a copy of which I have here solely for purposes of shameless self-promotion. Well, to what extent does the U.S. experience exemplify what other jurisdictional entities ought to do in their own enforcement work? Without doubt, EPA's enforcement program has been the catalyst for quite a number of laudable environmental achievements. In particular, the enforcement initiatives of EPA against iron and steel mills, petroleum refineries, abandoned hazardous waste facilities, electric utilities, paper mills, automobile manufacturers, municipal sewage treatment plants, large home builders, acid plants, and cement-making facilities have yielded immense pollutant reductions, enormous public health benefits, and important commitments to perform environmental mitigation. At the same time, however, with respect to certain other significant sources of environmental harm, EPA enforcement has resulted in relatively little environmental progress to date. These areas of disappointment include the dredging and filling of wetlands, air pollution from concentrated animal feeding operations, contamination of groundwater that's not currently used for drinking water purposes, and the elimination of adverse health effects from hazardous air pollutants in certain areas. It's also done little to encourage regulated firms to go beyond regulatory requirements by influencing internal economic considerations of regulated entities and shaping environmental values, topics that I understand Lee Paddock will be addressing in his presentation. To understand the reasons for EPA's enforcement inconsistencies, it seems useful to examine EPA's enforcement performance with respect to the conditions or criteria that lead to enforcement success. These conditions are set out in the one-page handout that I've prepared that I hope you all have a copy of. Let's consider how much EPA's enforcement work during the 42 years of the agency's existence reflects the presence or absence of those 9 enumerated conditions. First, I think it's fair to conclude that the United States does have an independent judiciary that typically decides cases before it neutrally and impartially. Moreover, in the wake of judicial decisions, the mandates of U.S. courts tend to be widely accepted and adhered to. That is not to say that the judicial system in the United States is perfect. In recent years, as was true in the distant past, partisan politics has played a role in the selection of judges and justices, including at the U.S. Supreme Court level. In my view, that's a worrisome and pernicious trend that bears watching. In addition, there are still problematic instances of judicial incompetence and corruption, and in some areas the courts have interpreted environmental laws with hostility or in confusing and ambiguous ways. Nonetheless, I think on balance, the United States still deserves high marks for its unbiased judicial system and respect for the rule of law. Does the United States have an effective and enforceable set of environmental laws? Well, the short answer, I believe, is that with regard to their substantive content, U.S. environmental laws have been a mixed success. Many of the major U.S. environmental statutes, such as the Clean Air Act, the Superfund Act, the Clean Air Act, have been quite effective in the sense that their implementation has led to notable decreases in environmental pollution. On the other hand, however, some of the same environmental statutes contain regrettable gaps and loopholes. For example, the Clean Water Act does little to limit so-called non-point source pollution, that is runoff from farms, forestry, and other unchanneled sources that significantly impacts and impairs water quality. Moreover, the U.S. Congress has repeatedly failed to pass comprehensive national legislation directly regulating greenhouse gas emissions that contribute to global climate disruption. In that context, I believe responsibility, sound science, and common sense have been supplanted by sophistry, misinformation, and disinformation, creating a basis for national embarrassment, if not shame. With respect to the presence of legal sanctions that will deter non-compliance, on the other hand, the U.S. experience has been more positive. Most federal environmental laws do authorize the courts to impose meaningful monetary penalties, both in civil enforcement litigation and in criminal prosecutions. Furthermore, criminal violators of environmental requirements can be and have been subject to periods of incarceration. EPA has adopted and implemented a civil penalty policy requiring at a minimum that polluters pay penalties that remove any profits that they earned as a result of their noncompliance, in addition to a sum to reflect the gravity of their violations. That policy is not binding on the courts, however, since with one exception, there is not a statutory mandate to remove profits from noncompliance. As a result, individual judges can and do vary in the magnitude of the sanctions they've imposed on individual violators for the same infractions, especially in civil enforcement cases. Despite these imperfections and exceptions, however, U.S. environmental laws do at least permit the imposition of meaningful violation deterring penalties. Turning to the conditions that concern the effectiveness of the enforcement work of administrative agencies, I think EPA has been very successful in recruiting, training, and retaining a top-notch, highly skilled professional staff. This staff is a well-integrated blend of engineers, scientists from various disciplines, and attorneys. Typically, in my experience, these people are both tough and fair. They have a great deal of passion for the work they do, as well as a strong work ethic. Moreover, as far as I know, little or no corruption exists among members of the EPA enforcement staff. Similarly, both among its senior executive service and at lower levels of the organization, EPA has been blessed with a superb cadre of career enforcement supervisors and managers, often drawn from the ranks of the agency's professional staff or from the Department of Justice. In my opinion, this group has done an exemplary job of training and guiding the people they supervise. With respect to environmental enforcement with respect to support for environmental enforcement from elected public officials and political appointees, the U.S. experience has really been anything but uniform. Although U.S. presidents and their White House staffs have varied greatly in their attitudes and environmental policies since EPA's founding, my research has uncovered very few instances of attempts by U.S. presidents to interfere directly with EPA's enforcement work. The major exception occurred in 1981 and 1982, early in the Reagan administration, when the White House orchestrated an ultimately unsuccessful effort to undermine, if not abolish entirely, the agency's enforcement program. However, that tumultuous but short-lived period aside, the White House has not typically attempted to intervene directly in EPA's development of enforcement cases. Unfortunately, the same cannot be said for all other executive branch officials. For example, during the George W. Bush administration, there's evidence that both the then Vice President and EPA's then Assistant Administrator for Air and Radiation attempted to derail an intensive, ongoing agency initiative to enforce Clean Air Act new source performance standards against electric power plants. On the other hand, throughout nearly all of EPA's history, no matter which political party has occupied the White House, EPA has had the good fortune to have had a set of assistant administrators for enforcement who are generally highly professional and openly supportive of EPA's enforcement efforts. The U.S. Congress has been remarkably inconsistent since 1970 in its attitude toward EPA's enforcement work. At times, our Congress has been immensely supportive, even holding oversight hearings intended to bolster EPA's reputation and stature as a strong enforcer. On other occasions, the U.S. Congress has sharply criticized the agency's enforcement efforts with the goal of prodding EPA to be more active and aggressive in its enforcement. And on still other occasions, including quite recently, members of Congress have harshly disparaged the agency's enforcement program for being too zealous and draconian, even publicly using such terms as Gestapo and jackbooted thugs to describe EPA's enforcement staff. One area in which I think the U.S. experience with environmental enforcement has been consistently inadequate has been with respect to the staff and financial resources allocated by Congress for the EPA's enforcement program. EPA's overall appropriations have simply not been sufficient for the agency to be as effective as it might be in enforcing national pollution control standards. More than 30 years ago, John Quarles, the agency's first deputy administrator, observed that due to a scarcity of resources, today, quote, EPA cannot perform its workload, end quote. As bad as things were in 1980, EPA's resource shortfall worsened notably during the 1980s, 1990s, and 2000s. During this period, EPA's already significant responsibilities in enforcement as well as elsewhere grew enormously, as measured by the laws passed by Congress and by a vast expansion in the number of industrial pollution sources that are subject to EPA regulation. Despite this, even though it was nominally flat, EPA's working budget effectively decreased during the late 1990s and most of the 2000s because Congress repeatedly mandated cost of living pay increases for federal agency employees without appropriating any extra funds to federal agencies to cover the cost of those compulsory raises. Does EPA have a workable, efficient organizational structure for its enforcement activities? The answer, I think, is yes in part and no in part. In 1993, EPA's top managers reorganized the organizational structure of the agency's headquarters to establish the arrangement that prevails today. In doing so, they recreated a unified Office of Enforcement, which had been formally dissolved 12 years before. So all of EPA's enforcement professionals, regardless of their disciplinary background and function, are now housed in a single headquarters organizational unit. Unfortunately, however, after reorganizing headquarters in 1993, the agency's then top management team declined to take the next logical step by requiring each EPA regional office to restructure its operations in a manner that parallels EPA's headquarters structure. As a result, EPA enforcement at the regional level has remained something of a crazy quilt of organizational structures. Some regions have reestablished unified interdisciplinary enforcement divisions. Others have retained arrangements that segregate enforcement professionals along disciplinary lines into different offices. This inconsistent set of regional arrangements for enforcement has created confusion, not only for outsiders trying to understand the organizational structure of particular regions, but also, I've been told, even sometimes for EPA's own headquarters personnel. It's also resulted in some duplication of function, a most unwelcome phenomenon in a situation of resource scarcity. Finally, how should the agency's overall environmental enforcement approach or philosophy be assessed? Well, here I think, subject to some of the criticisms that Lee Paddock will suggest, the U.S. experience has been successful, especially with regard to enforcement actions that EPA has taken against large national or multinational corporate industrial polluters. With the exception of only one relatively brief period, the agency's enforcement efforts have consistently been based on a theory of deterrence. Under this approach, violations of the law are to be detected promptly and punished fairly and appropriately as a way of deterring individual violators and others similarly situated from violating the law in the future. EPA has also sensibly supplemented its formal deterrent enforcement approach in a number of ways. For example, it has periodically made efforts to publicize newly issued regulations at gatherings of industrial trade associations, and it's been willing to decrease or eliminate demand for civil penalties against companies that can demonstrate that the imposition of higher penalties will place the company in severe financial distress. However, in general, EPA's more formal, assertive, deterrence-based enforcement approach has prevailed, and it has been useful, I think, as a means of promoting environmental compliance by large-scale regulated entities. In sum, as exemplified by EPA, at the national level, the United States' environmental enforcement work has substantially succeeded in some areas and been relatively ineffective in others. In terms of the relevant criteria for enforcement success, the U.S. environmental enforcement effort has excelled as to some of the criteria, such as judicial independence and the professionalism of the staff and managers in enforcement. It's satisfied some of them partially, and it's done poorly with respect to the adequacy of enforcement resources. Other nations would thus be well advised to do all that they can to replicate what's worked in the United States experience while rejecting what we have done that's not been helpful. While effective and professional environmental enforcement is not the only way to protect public health and nature in a sustainable fashion, it really can be an immensely valuable tool to that end. Thanks.
Thank you for Professor Mintz, and on behalf of EPA, thank you for those kind words. You had me at highly professional staff, so thank you very much. Our next speaker this morning is Dean Lee Paddock, who is with the George Washington University School of Law. Dean Paddock has an extensive career. I won't take any more time to go into it, but I do want to say one thing about Dean Paddock. When he calls me at the EPA and says, I have a student that I'd like to recommend that you bring on as a law clerk, that's the only reference we need. Paddock's word is gold. Dean Paddock.
Well, good morning. And I too would like to thank Bob Percival for organizing the meeting today, Eves and Jamie for all of the work they put into the Academy. It's a pleasure to be here this morning. I'm going to talk this morning about a concept that I've been working on for the last couple of years, which I've called Beyond Deterrence, which is looking at compliance and enforcement in the context of sustainable development. The essence of the theory is that we can do all the enforcement we want and do it really well, but that's not enough to get us to our ultimate goal. And what I'm trying to do is look for co-benefits in the enforcement process. So Klaus Bosselman and David Grinlinton have linked sustainability to fundamental concepts such as freedom, justice, and equity. They note that only a sustainable society capable of working with nature, not against it, will have a chance to survive. This effort will require not only strengthening regulatory systems, but also continuing efforts to reinforce the economic signals that support more sustainable behavior and to build societal values supporting sustainable outcomes. While there are a number of external economic signals that affect corporate behavior, such as subsidies and taxes, I think the much more interesting issue today are the internal economic factors that are increasingly pushing companies to adopt more sustainable practices. And many of you have looked at these issues. There's a long list: reputation, customer demand, investor pressure, supply chain, operational risk, insurance, lending, a whole range of issues that are internal economic factors that drive companies to go beyond what the law requires. So access to market and product differentiation, and then issues like operational efficiency. Compliance and enforcement programs, of course, are a necessary part of any effort to achieve sustainable environmental outcomes. But simply enforcing regulations in their current form, or even significantly enhanced regulatory programs, is not sufficient to achieve these outcomes. Because compliance with existing environmental regulations is not sufficient to achieve larger goals of sustainability, it's important for those working on compliance and enforcement programs to think strategically about how they might leverage their work to influence internal economic drivers of environmental behavior and to build societal values that help achieve results beyond compliance. Enforcement officials have thought about this in some ways, like environmental auditing policies and compliance education. But as Joel mentioned, most environmental officials rely on the idea of deterrence as the principal motivating factor, and deterrence is very important. U.S. environmental law has had significant effect through deterrence. One example in Minnesota, when we passed our environmental crimes legislation, for example, the indicator that there was a deterrent factor was the number of seminars law firms were putting on for companies to inform them about the new environmental crimes laws. So deterrence is important. But Gunningham, Thornton, and Kagan found in a study of electroplating and chemical companies that neither specific nor general deterrence played a major role for these companies in shaping their environmental behavior. They concluded that regulation works through a complex mixture of pressures, fear, and normative duties. A critical question then for compliance is whether these programs should be designed simply to deter violations, or whether the programs can also play a role in preventing problems by helping shape the economic and values drivers that are essential to achieving more sustainable outcomes. A recent Oregon Department of Environmental Quality study noted that by integrating a variety of regulatory tools, each consciously chosen for its effectiveness in a particular application, an agency can create a system that both pushes and pulls regulated entities towards environmental protective behavior. Such a holistic approach, they note, can work to decrease direct compliance costs, increase direct cost of non-compliance, and increase the probability that non-complying companies will experience further direct and indirect costs through customer pressure and customer and community pressure. Among internal economic drivers, reputation is particularly of importance for many large companies. Enforcement actions can clearly have a significant impact on reputation. Williamson and Lynch note 5 factors that they believe can have a significant impact on compliance for larger corporations. The environmental impact of the firm's products and processes, customer power, customer interest, corporate brand visibility, and community pressure. They note, however, Williamson and Lynch note that at least 2 of those factors are needed in order to have a high pull factor on environmental behavior. And they note that many of those factors don't exist with respect to smaller businesses. This research suggests that it may be more important to target enforcement towards companies that do not have a high public profile, while using other tools, such as recognition, to encourage companies with a higher public profile to pursue beyond compliance behavior. Still, compliance and enforcement officials may be able to influence the behavior of smaller companies by, among other things, supporting expanded use of tools such as private supply chain requirements. Michael Vandenberg noted in a study of 78 firms that over half of those firms imposed environmental protection requirements on their suppliers. This process, sometimes referred to as the Walmart effect, is increasingly important for businesses. In Rio, I attended a session at the U.S. Pavilion put on by the Consumer Goods Forum, a forum made up of a lot of the large consumer products companies around the world, including Nestle's and Coca-Cola. Those companies were talking at this forum about the need for companies to move beyond the idea of simply relying on green certification in their supply chain to what they called green chain of custody, so that the company would know at each step in the process where their products were coming from. And they're particularly emphasizing the sustainable forestry as one of the main points in the work that they're doing on this supply chain of custody idea. The lesson to be drawn from these discussions is that in order to achieve optimum results with limited resources, government agencies must continue to develop their understanding of how internal economic factors affect corporate environmental decision-making and take these factors into account in designing management systems and setting priorities. Like economics, values are a key driver of environmental behavior. Don't want to get to that one yet. People tend to act in pro-environmental ways when a situation activates a feeling of moral obligation to do so. The values, beliefs, norms, concepts suggest that values underlie and affect everything, from how a person interprets information, to what they are aware of, to what they think humans are responsible for, to what they do about it. Achieving sustainability requires increased emphasis on aligning public values with needed environmental outcomes. Properly designed compliance programs can, through education, social marketing, and other tools, play an important role in building these societal values. My paper, which is published this month in the Environmental Law Reporter News and Analysis, suggests 7 ways in which enforcement programs can take into account internal economics and values, and I think achieve co-benefits through those. The first of those, and I'll discuss 5 of those in a little bit of detail, The first of those is the idea of employing a full range of enforcement tools. In too many occasions and in a number of states, the kinds of enforcement tools that agencies have is very limited. Many of the states in the U.S., for example, might only have notice of violations and the ability to file a civil penalty action for a violation. This greatly restricts the number of enforcement actions that can be pursued and the visibility of those enforcement programs. Using a full range of tools can serve to remind companies of the need to comply, reflect to the public the fact that environmental issues are important public values, and reinforce the need to act in conformity with those values. These reminding, reflecting, and reinforcing functions are best accomplished when there is regular interaction between the regulators and the regulated community that occurs in settings that range from education to administrative enforcement to criminal prosecution. This approach, I think, is somewhat analogous to the idea of community-based policing. Community policing, among other things, is designed to strengthen community values in an effort to prevent crime, not just punish violations. As Malcolm Sparrow noted in his book, The Regulatory Craft, for regulators, continuing in a traditional enforcement-centered mode, given the constraints of shrinking budgets, declining public tolerance for the use of regulatory authority, and clogged judicial systems, is now simply infeasible. A second area that I wanted to highlight in this regard is the idea of promoting learning and self-evaluation. Environmental auditing programs, for example, provide for penalty mitigation for identifying and promptly correcting problems, such as the programs that EPA has had in place now for over 15 years. These environmental auditing provisions rely on a number of internal economic drivers, such as reputation, cost avoidance, and employee morale to drive increased compliance activity and beyond compliance activity. Other countries are adopting interesting new approaches. The Netherlands is using an approach referred to as self-management supervision. The approach changes the focus of inspections from examining specific equipment and monitors to reviewing the quality of the company's adopted company self-management system, building on the ISO 14001 idea, I suspect. In the same vein, British Columbia's compliance management program recognizes that achieving sustainability requires, quote, shared stewardship, and is one of the key elements of the ministry's compliance strategy. A third tool that I wanted to talk about briefly is social marketing. Social marketing can be used to influence pro-environmental behavior in two ways: by raising awareness about environmental problems and by framing and packaging choices regarding that problem in a way that activates values held by individuals, making action more likely. Governments are often, at least publicly, reluctant to support social marketing. But in fact, in the United States, governments do this all of the time. We do it through things like drug abuse resistance education, a whole range of social programs where social marketing is the center of the activity. In the Netherlands, of course, social marketing has been central to its national environmental policy plan. British Columbia has incorporated social marketing as an element of its water stewardship strategy. The strategy notes that technically sound, cost-effective programs can often fail if pertinent information doesn't reach the right audience. With few exceptions, a communications or social marketing strategy should be an integral part of any program. And this is an example of social marketing in our community, which is Chesapeake Bay. you can get the message there, right? Protect the crab cake population by protecting Chesapeake Bay. All right, I have just two others that I wanted to highlight quickly. The next one is the private enforcement through supply chains. Again, Michael Vandenberg has observed that in some cases, this new form of private governance transfers pressures created by public entities, but in many cases, it bypasses public entities altogether, transferring demands for social amenities directly from the citizens of one country to the firms operating in another country. He concluded that government policymakers can include promotion of private contracting among the available options when they encounter environmental harms that are difficult to reach with tools of public and public-private governance. Finally, the last tool I wanted to mention is recognizing superior performance. A number of countries recognize corporate leadership. In the U.S., EPA's performance track for 10 years recognized leadership companies in the environmental area who made commitments to environmental performance beyond what would be required by the law. That program was discontinued early in the current administration, but a RAND Corporation study of the program found that the application process itself taught companies how to quantify the broad environmental impacts of their activities and to set goals for continuous improvement. They noted that performance track members also reported a range of changes in corporate culture, including increased consideration of environmental issues in formal decision-making process and greater employee awareness. Environmental sustainability is a difficult goal that requires a strong regulatory system, but moving towards sustainability also requires companies and the society as a whole to change behavior. The considerable resources that many countries invest in compliance and enforcement need to recognize and reinforce these changes by designing strategies that leverage internal economics and help reinforce sustainable values. Thank you.
Thank you so much, Professor Paddock. At the EPA, we've been adopting some of these concepts as well, and we have a new program underway called Next Generation of Enforcement, where we're looking at ways to improve our regulations along the lines that you were discussing. And one of the quick examples that we have taken is we observed over a period of years that one of our sister agencies, the IRS, was allowing taxpayers to take as a tax deduction dependents under 18 years of age. And for years, people would have to identify first the number of dependents, then they were asking them to list them by name, and then one year the IRS thought, let's ask for their social security numbers. And although there was some public opposition to getting a social security number for a little baby or a 2-year-old child, the first year that program went into effect, the number of children in the United States went way down, according to the IRS. So when we're in the behavior modification business, we have to modify it. Our next speaker is Professor Alex Wang, who's visiting assistant professor at the University of California, Berkeley Law School. And prior to his appointment at the university, he was the senior attorney for the Natural Resources Defense Council based in Beijing, where he was the director of the China Environmental Law and Governance Project. Having just spent some time in Beijing, there's a lot of work to be done there. So please welcome Professor Alex Wang.
Great. Okay, good morning. It's a pleasure to be here today, and thank you to Professor Percival and the entire organizing team for putting on a truly excellent program. My talk today is entitled The Search for Sustainable Legitimacy. It's an effort to shed light on a shift in China's environmental governance that, in my view, has not been adequately understood. Certainly not outside of China, but at many times not even within China. These remarks are drawn from a much longer law review article I'm working on, planning to complete this summer. And my observations are also based on my 7 years working in China on collaborative projects with government, NGOs, lawyers, judges, and citizens in the environmental area when I was with NRDC. In my talk today, I'm going to try to explain China's recent actions on environmental protection through a broader political lens that draws a connection between China's environmental measures and leadership concerns about regime legitimacy. I think these lessons are not just applicable to China, but may be relevant in particular to other developing countries, but also possibly to developed countries like the US and other countries as well. And I'll elaborate on that in a moment. Okay, so let's get started. China, as you most likely know, has some of the most challenging environmental problems in the world. It's the leading emitter of a wide range of pollutants, sulfur dioxide, mercury, greenhouse gases, and so on. And its environmental quality is among the worst in the world. Furthermore, China's enforcement of its environmental law regime has historically been very weak. But in 2006, China garnered a great deal of attention because of its passage of high-level environmental performance targets aimed at government bureaucrats. These were announced as part of China's 11th five-year plan that began in 2006. Specifically, China established a 20% energy intensity reduction target and 2 pollution reduction targets, mandating 10% reductions in sulfur dioxide emissions and chemical oxygen demand. A few years later, China announced targets for carbon intensity and non-fossil energy, among others, in the run-up to Copenhagen, and built these targets into the 12th five-year plan that just began last year. So how many people have heard of these targets? Just to take a quick survey. So a reasonable portion of the room. Now, these performance targets have generated a great deal of discussion. Many commentators have sort of breathlessly suggested that China has begun a green leap forward, and they've heaped praise on China for its environmental actions. Now, others, perhaps upset at the continued worsening of China's environmental condition, have argued that these environmental targets are largely a PR effort aimed at diverting attention away from China's environmental crisis. But I think few people have really looked under the hood of this system, so to speak, and figured out really what is making this system work or not work. So my research over the last 2 years or so suggests a more nuanced picture than has been presented by either of the views on the extremes of the spectrum. In short, I've found that China's environmental targets are driven by much deeper concerns going far beyond environmental policy. I argue that China's effort to implement its environmental targets is in fact part of a broader strategy to uphold the very legitimacy of the Chinese state. And to be clear, when I'm talking about legitimacy, I'm referring to leadership concerns about regime stability and collapse. Think the Soviet Union, think Egypt, and so on. And I argue that China's environmental targets represent a use of environmental protection as a tool for promoting the 2 core values that have been at the heart of Chinese regime legitimacy over the last 30 years, namely GDP growth and social stability. At the same time, the system is also being used actually to promote a cleaner environment that's being demanded by an increasingly concerned public. Now, this linkage of environmental aims with GDP growth and social stability has pros and cons. On the positive side, in tying environmental objectives to the ultimate regime self-interest in maintaining legitimacy, we see some real benefits for environmental protection. In particular, this approach has driven massive investment in environmental technologies and clean tech, This is money that before would have been spent on other objectives. And it's resulted in upgrade of China's industrial stock through the shutdown of so-called backward industrial capacity. You've probably all seen the headlines about China's green tech leadership, as well as controversy over subsidies and support to the Chinese solar and wind industries. These dynamics are all arising out of these incentives created by China's environmental targets. So for developing countries in particular, I think China's approach offers some interesting lessons. The focus on driving the economy through investment in environmental technologies and clean tech may be of particular interest to countries forced to deal with severe environmental problems before they've reached developed country status. And these efforts to shut down the oldest, dirtiest plants are an important solution to the problem of regulating small firms that's prevalent among developing countries. While much of the literature in this area, sort of developing country environmental regulation, is focused on how to better regulate these small, less efficient firms, China's strategy has been simply to try to get rid of the small firms. So the broader strategy is to consolidate industries in the name of creating globally competitive enterprises, but at the same time, it creates an incentive for larger facilities that more likely have the capacity and the resources for environmental compliance. So it's interesting, and it's different than perhaps what we're familiar with in particularly the developed world. Nonetheless, the way that China has chosen to elevate these priorities has some serious shortcomings. This is an approach marked by top-down, hierarchical management of a vast bureaucracy, and currently with little public input and with relatively little transparency. So the result is that there are substantial principal agent problems in the system that threaten China's efforts to use environmental tools to counter declining legitimacy. For example, counties build wastewater treatment plants, but they don't operate them. Power plants install desulfurization equipment, but they don't turn it on. Local officials cut off power to hospitals and street lamps to meet and street lights to meet their energy efficiency targets. Even worse, data falsification problems render it difficult, if not impossible, to know just how bad the implementation problem might be. Take China's so-called gigaton gap in CO2 data. This is the 1.4 gigaton difference between central and provincial CO2 data that was reported in Nature magazine last month. This discrepancy in data between central and provincial is equal to the annual CO2 emissions of Japan. So maybe China's efforts are bearing fruit, but given data problems, it's hard to know for sure. And won't these problems only get worse as the number of environmental targets proliferates or as government attention eventually moves on to other non-environmental priorities? So in the time I have left, I'd like to cover a few details of these themes that I've mentioned. And at the end, I'll offer a few thoughts on potential reforms to the system. I'd like to spend a few minutes to describe exactly how China has implemented these environmental targets. This will help to answer a few questions that are probably on many of your minds, namely, why would we expect these targets to perform any better than environmental law said, which has been poorly implemented in China for decades? Yet in the 11th five-year plan, there was a subtle but critical difference that would create a much greater incentive for implementation of environmental objectives. The key was that responsibility for meeting these environmental targets was now assigned to the so-called leading cadres in each level of government, that is, the governors, the mayors, the county heads throughout the country. This represented a major change from before, where these environmental targets were largely the responsibility of the environmental regulators themselves. Also, the priority of these targets was elevated significantly. Environmental targets had always been soft targets in the past. There were few consequences if you didn't meet them. Now these environmental targets were designated as hard targets, and central leaders would later even call them veto targets, which is the highest level priority level for targets. This meant that failure to meet the targets would mean career consequences, loss of promotion opportunities, bonuses, awards, even firing in the worst situations. This raised environmental targets to a rarefied level previously reserved only for economic growth, social stability, and the one-child policy. So think about this for a second. This was a seemingly radical turn towards environmental protection. Had Chinese leaders suddenly become tree huggers? Given the magnitude of this shift, is it any wonder that many observers were skeptical that this was nothing more than a PR effort? But an examination of the underlying objectives of these environmental targets offers some clarity and perhaps makes the sudden elevation of environmental objectives seem less implausible. First of all, if you look at leadership statements and implementation guidance for this program, it makes clear that the primary goal of environmental and energy targets was actually to address perceived problems in China's economic growth model. The focus was primarily economic. The head of China's most powerful agency, the NDRC, said that, quote, energy saving and emissions reduction targets, these environmental targets, are a very effective entry point and breakthrough point for adjusting economic structure, changing the economic growth model, and elevating economic efficiency. Official documents would say that environmental targets would be a, quote, important hook for promoting scientific development. If you looked at the central implementation guidance for the program, it provided that investment in pollution control equipment, such as wastewater treatment or desulfurization, would be a central means of meeting these targets. Central officials were also aware that this investment-based approach to target compliance would actually meet with the least resistance with local officials, who, after all, probably have never met an investment project they didn't like. Implementation guidance also provided pollution reduction credit for shutdown of old facilities. So central policy on shutdowns was driven by this desire, as I mentioned before, to consolidate industries and to create a larger, more efficient set of facilities in China's industrial stock. But local actors could also benefit from these shutdowns. SOEs, the state-owned enterprises, might be offered an approval for a new, larger project only on the condition that they shut down older facilities first. Some companies might like to see their competitors shut down and might press for that. Local officials might want to shut down a facility if the land underneath that facility happened to be very valuable and could be sold to real estate developers for a premium, for example. So in the end, based on my research, I found that, and it may come as no surprise, that the vast majority of these pollution reductions in the 11th five-year plan came from investment, about 60 to 70%. And maybe a quarter came from shutdowns. And only a very small percentage came from the kind of more traditional things we talk about in the environmental law field, kind of regulation and the impact that has on pollution. Now, interestingly, the environmental target system would also be used to address environmental problems that caused acute social instability. I first noticed this in the heavy metals context. In 2009, more than 24 protests around the country occurred due to heavy metal poisonings of children. And after that, a series of emergency meetings were held, and central officials announced hard environmental targets for 6 heavy metals. Another example, just a few years ago, and this you may have seen headlines about, the U.S. Embassy in Beijing placed a PM 2.5 monitor on the roof of the embassy in Beijing. And began to broadcast hourly updates by a Twitter feed. This flow of data created a public outcry, and on numerous days when there were discrepancies between the U.S. and the Chinese data, people became upset about that. And in the end, that drove the government to monitor PM 2.5, and they announced hard targets for mayors with respect to PM 2.5 air quality levels. So in instances where environmental problems led to protests or created the potential to galvanize the public against the government, central officials turned to hard environmental targets. So again, the point here is that these environmental targets were used primarily for economic aims and then also for stability aims. But these targets were also part of a more general push for a harmonious society, a concept promoted by President Hu and Premier Wen, who came into power in 2002, to address a range of social ills that had arisen out of China's economic growth model. So to summarize, my claim is that China's environmental targets should really be understood in this broader political context as a way to address risks of declining legitimacy, The main goals of the system were to shore up risks to economic growth and stability, but also to promote environmental protection, which fit into this harmonious society rubric. Now, this research of mine into environmental targets in China is consistent with a broader political science literature on China's adaptive authoritarianism, or what has also been called China's authoritarian resilience. That body of literature tries to offer an explanation for why China has survived and even thrived when other authoritarian states like the Soviet Union have collapsed. And the thrust of this literature is that China has done a better job of uncovering problems and responding to those problems than most analysts had expected. This literature hasn't looked at Chinese environmental protection, but I think that narrative from that literature helps to support some of what I'm talking about here. For example, David Shambaugh, who I think is at GW, has shown that in the 1990s, Communist Chinese Party researchers studied the reasons for the Soviet collapse, and then officials implemented governance responses to that. In 2004, the party issued a statement that said the party's governing status is not congenital, and the statement invited examination of ways to shore up declining regime legitimacy. This led to an outpouring of official research on possible alternatives to a legitimacy primarily based on economic growth. Scholars raised ideas like new ideological approaches, reforms in governance, rule of law approaches, and so-called harmonious society approaches, which included social measures like improved health care, reducing rural financial burdens, social security, and environmental protection. In 2004, a Chinese environmental vice minister wrote an essay making explicit the regime risks of relying solely on economic growth. In Western countries, he said, there were many serious economic crises, but these did not result in a crisis of legitimacy for the political regime because the legality of their rule was not entirely tied to economic changes. Environmental protection, he said, was an important alternative basis of stronger legitimacy. And it was against the backdrop of these discussions and these investigations that Chinese authorities established the 11th Five-Year Plan environmental targets. Now, this is all that I have time for this morning, but I'll end with two comments. First, you're likely wondering, how has this system performed in practice? I go into great detail on this in the longer paper, but the short answer is that there appear to be many problems with implementation, and those problems create some risks for China's goals. Second, what are the possible solutions? And I think the answer to these problems, broadly speaking, is that there needs to be greater government and enterprise accountability. As I mentioned, the current system is really an internal administrative one with little external independent oversight. And we all know what happens in the absence of independent oversight. So what are specific solutions? China is, in fact, already experimenting with transparency and public participation measures. These deserve to be expanded, both because citizens demand the information and the participation, but also because it will help China to better achieve its environmental goals. So to conclude, China is really in uncharted territory right now. The system it's put in place has terrific potential, but right now it's hamstrung by some problems of insufficient accountability that render it impossible to tell just how well the system might be doing. Thank you very much.
Thank you so much, Professor Wang. We will have some time for questions after our next panelist, who is Steve Wolfson, who is the Acting Assistant General Counsel of International Law at the U.S. EPA in Washington, where Mr. Wolfson coordinates OGC's international capacity building and has helped to train lawyers in many countries around the world. And he also has been involved in a variety of treaty negotiations with an interest on environmental subjects. So please welcome Steve Wolfson.
Well, thank you, Mike, and thanks to Professor Percival and the Maryland team for bringing us here. As we heard yesterday, despite a great deal of wrangling and expressions of disappointment over the outcome at Rio, the Rio Plus 20 conference yielded some positive outcomes. I'm going to talk about where things are going in terms of building environmental governance capacity, what the role of law is, what are some emerging efforts, and then offer some suggestions for the work ahead. Implementation of international goals and obligations depends on effective national and local governance for on-the-ground implementation. The EPA Administrator, Lisa Jackson, has made building strong environmental institutions and legal structures one of the top priorities of EPA's international work. And EPA General Counsel Scott Fulton spoke yesterday about some of the advances that were made on these issues at Rio Plus 20. Law is important, but the shift that General Counsel Fulton talked about yesterday is a shift to focusing more on implementation. And the International Society of Auditors made a very important contribution on this issue at Rio. Why auditors? Well, they're the ones who look at what we say and then compare it to what's actually happening on the ground. Their working group on environmental auditing provided an analysis that shows that environmental laws are generally not self-executing, but instead require legislation, policy, administrative capacities for implementation and enforcement of the regulatory framework. I call this the no shortcuts rule. In many countries, the institutional framework lacks clarity regarding roles and responsibilities of different parts of the government. And there's a need for improved coordination. So this is a second finding from the auditors working group. So I call this the rules of the road imperative. And then a third finding from the auditors is that environmental governance capacity building and institutional development need to become priorities. I don't have a name for this, but I think it means we have a lot of work to do. The shift towards focusing on implementation can be seen in the future we want, the Rio Plus 20 outcome document, particularly in paragraph 10, in the language on institution, the need for institutions to be transparent, accountable, effective, and democratic. Ideas that receive further elaboration in the outcome document produced by the UNEP World Congress on justice, governance, and law for environmental sustainability. In particular, in the discussion in that outcome document of the core features of effective governance systems. So my own reflection from my experience with capacity building, I've done some capacity building first in Central America on environmental laws there, even going back before the Central America Free Trade Agreement, and then more recently in China and a bit in the Middle East as well. My reflection is that when we actually look at what is in the laws of countries that are trying to improve their environmental protections, we sometimes find the laws to be thin in ways that can seriously impede the effectiveness of these laws in protecting the environment. Now, I'll give a couple of examples here. Sometimes the effectiveness of laws on the books is constrained by the lack of substantive criteria for standard setting or the lack of transparent procedures for standard setting. Sometimes the constraint is the lack of mechanisms for concrete implementation or for coordination among different parts of the government. Sometimes there's a lack of provision for judicial review or citizen suits. Sometimes there's a lack of provisions for civil enforcement or for penalties that are adequate to deter violations. So the imperative is not only to enact strong environmental laws, but to implement and enforce them. But that entails ensuring that the laws themselves have adequate criteria, procedures, coordinating mechanisms, remedies, and enforcement provisions. We heard yesterday another kind of constraint in a discussion about Central Asia, that sometimes environmental implementation is impeded by a lack of enabling conditions, the difficulties that are entailed by the absence of a backdrop of the rule of law. But we also cannot generalize too broadly here. What I've just described is not a uniform picture of all environmental laws in all developing countries. The good news is that there are some very important innovations that are underway all over the world. And some of these have been discussed here, some of them were discussed at Rio. We heard Professor Robinson mention yesterday the new writ of kalakasan in the Philippines, providing for citizen actions. The Chilean environmental impact assessment law has a new provision for outreach to vulnerable and historically marginalized communities, what in the United States we've been calling environmental justice. Paraguay has a law on payment for ecosystem services. And Professor Wang has done important work on the implementation of China's new information law. And in my work with China, I've seen that there actually is consideration of a broad array of other legal reforms, including the possibility of citizen litigation, increased penalties for violations, coordination, regional coordination on air quality management, and pollution reporting, as well as many others. So I would conclude that the focus on implementation does not preclude law reform, but it may actually require law reform. It's critically important to look at what the laws actually say in some detail, and also to look at how they function on the ground, and to consider what steps are needed to give life to the animating spirit behind the words on the page. So what are the steps ahead in terms of strengthening environmental governance? Well, we're already seeing the emergence of a number of new fora. The World Bank is starting a new network called the Global Forum on Law, Justice, and Development. The UNEP World Congress called for continued engagement by the community of judges, auditors, prosecutors, and other legal experts on issues of building environmental governance capacity. A group called the World Justice Project has developed a rule of law index, and they are now working to incorporate environmental law into that index. Professor Robinson has been working on an International Institute for Judicial Education, and the UN Institute for Training and Research is working with UNEP and also the World Resources Institute on implementation of Principle 10. This is only a partial list. There are many more activities going on. I think this reflects the growing momentum for new partnerships and initiatives to strengthen environmental governance in countries around the world. But given tough economic times, tight budgets, and the elusiveness of international consensus, how can we ensure that these and other efforts to strengthen governance are meaningful, effective, and lasting? Well, I'll offer a few suggestions that might provide some guidance, might also be prompting of some research ideas. Analysis of governance gaps and prerequisites for success can aid in identifying what needs to be addressed and can assist in the development of indicators or other performance measures to track progress. It's critical, given today's economic problems, to ensure effectiveness and efficiency of capacity building efforts. Finding ways to foster greater coordination and more collaboration can help do this, and can promote synergies as well. Enhancing information sharing on effective environmental governance and capacity building methods is critical. And we heard yesterday about a new effort, the Middle East Environmental Law Initiative. I think that's a good example of what we're talking about here. Creating an information clearinghouse, global and local, can increase awareness needed for coordination and collaboration to occur. There's also still a critical need for research and articulation of best practices and assessment tools for capacity building, design and enforcement of environmental laws, implementing mechanisms, legal structures, accountability processes. North-south, south-south, and triangular collaborations can be very useful in sharing experiences and tailoring solutions to local needs. I think the IUCN Academy can play a very important role here. I also think that stronger linkages are needed among the different entities in the international community, among UNEP, the UN Development Program, the International Network for Environmental Compliance and Enforcement, the auditors network, the multilateral development banks, national governments, judiciaries, NGOs, and others. We need stronger links. We need information sharing. We need to be working more together. I'll conclude with an analysis of some numbers. And my friends in China have a far more profound understanding of the deep meaning of numbers than we do, but I'm going to take a shot. Principle 10 of the Rio Declaration gets a lot of attention from those of us who are focused on law and governance, because we see the central importance of information access, public engagement, and access to justice for sustainable development. 10 years after the Rio Declaration, the Johannesburg Summit built on the ideas with important language on governance. Now it's 10 years after Johannesburg. And again, at Rio, at the Rio Plus 20 meeting, it was paragraph 10 of the outcome document that builds on this foundation with that language about the need for institutions to be transparent, effective, and accountable. And I think that paragraph 10 in the Rio Plus 20 document might become an important touchstone for a new generation. So I'd like to give my heartfelt thanks to Professor Percival and his colleagues here at Maryland for holding this conference, which is the 10th IUCN Academy Colloquium, so soon after Rio, because it gives us a reminder that we can't afford to wait another 10 years. We need to get going right away for the sake of the planet and all of us that depend on it. Thank you.
Thank you very much, Mr. Wolfson. Now we have some time for some questions, so if you'd please come up and use the microphone here. Dean Ottinger will be first. You'll be second. Welcome to University of Maryland, Dean Ottinger from PACE.
Private sectors, for the private sector's involvement, civil liability. I think corporations act very significantly from the danger of being sued civilly, not just by EPA, for damages that they cause through environmentally irresponsible activities. The other thing I would add is the inclusion of the costs of externalities in the choice of resources. If you include the costs of health care and premature deaths and destruction of environmental resources in your calculations of what you do in terms of the environment in the government, you find very quickly that coal and oil are far more expensive than energy efficiency or renewable energy. Alex Wang, I enjoyed your presentation. I do a lot of work in China. And the one thing that I think I would suggest you're adding to your work is the truly remarkable advancement of China in the sector of renewable energy. I mean, it is incredible. 10 years ago, China had no renewable energy, and today it's the leader in solar photovoltaics, solar thermal, and wind technology, to the extent that the United States is buying Chinese products in these areas. And that really has an important effect on reducing the unfortunate reliance on coal. Thank you.
If we could just urge you to go back to your seat in Congress, Dean Ottinger, we need more people like that, about 425. Comment from the floor. Or would someone like to respond to that, please?
Yeah, I just wanted to
While he
say
comes up.
briefly that I couldn't agree more with my friend Dick Ottinger about the liability issue. And in my full paper, I do talk about that as being one of the critical tools. And in fact, states like Minnesota, where they have Citizen Environmental Rights Act, which are open standing statutes, I think are a good example of one of the range of tools that should be available.
Thank you.
Thank you. Wang Xi from China, Shanghai Jiao Tong University. I have two questions for the three EPA officials in the panel. You talk about, can I take this? You talk about conditions for good environmental enforcement, especially for your talk. I think that's very good. But I'm wondering, maybe there is one more condition also is important. That is the supervision from the society, general public, for the EPA's work. Yeah. So if you agree, I would like to suggest you add one more. Yeah. Because for any government, if there is no supervision from outside of government, the government will tend to be lazy or even corrupted. That's my understanding. Mm-hmm. Okay.
I think that I would agree with you. Actually, enforcement has tended to do best when there's strong public support for it. It probably did the very best in terms of EPA's enforcement at the very beginning of EPA's existence, when there was just an overwhelming demand from the public for environmental protection, environmental enforcement. Usually that tends to happen when the pollution problems are most visible and obvious to the public. It's more difficult to get support where you have gases that could be doing significant environmental damage, for example, that are invisible and have no odor, and therefore the public is not aware of them. But I think you're absolutely right. I mean, public opinion plays a significant role. I think EPA has been fortunate over the years to have a pretty good level of public support, including especially for enforcement, because that focuses on the problems. It focuses on the worst case situations. But I would agree with you, sir.
Yeah, thank you. The second question is about the citizen suit. Do you think citizen suit really help for EPA to have a good enforcement of environmental law?
Yes, I do think they help. I think the situation with citizen suits is that they create an enforcement presence and a concern among those who are in violation, who are potential targets of citizen suits, and in that way they have a deterrent effect. In this country, in the United States, there are far fewer resources put into citizen enforcement than into government enforcement. And I'm talking about it in the broadest sense, both in federal enforcement and at the state and local level. So in terms of the overall force that government has, it's probably greater than citizens. But citizen suits play an important role in enforcement. In the U.S., for those who are unfamiliar with it, citizens can directly bring lawsuits against violators of environmental laws. They don't keep the penalties that they recover; those go to the Treasury. But they nonetheless can bring suits. They can also bring suits against the EPA administrator for failure to carry out non-discretionary duties. And to the extent that that happens, that's had a significant effect on the EPA's regulatory agenda. Some have criticized that for taking it out of the agency's hands and putting it in the hands of a sort of a disparate group of citizens. But I think on balance, citizen suits are a very good thing, yes.
Just to comment briefly on that, one of the important things, especially in the Clean Water Act citizen suits in the U.S., is the availability of information. So without the public having access to information, citizen suits are much less effective. And so that's one of the design questions that's really important. I do think that the existence of citizen suits by themselves, just like the existence of civil liability by itself, is one of the factors that can deter violations. It's a wild card out there, and it's nice to have those wild cards.
We have time for one more question if someone else would like to.
Sorry, one last comment.
Oh, very good.
Very
Well, you've traveled so far, so please.
Thank you. A comment for Professor Alex Wang. It seems to me that your conclusion is the Chinese environmental policy is for keeping the legitimacy of the Chinese government power. I think that's the same for any country. Either United States or Soviet Union or any country, environmental protection is a governmental work for maintaining the legitimacy of the government. So environment problem is actually not so directly related to the nature or the differences of the social system. Thank you.
Thank you. I would like to, at this time, before I thank the panelists, I'd like to again thank Professor Percival and his wonderful staff for helping to organize this conference. Many of you have dealt with Suzanne Langrel, who's the intrepid glue that holds this organization together by and by. And when we were in China, I wanted to thank Miss Langrel for all the work she had done in getting my visa and going to the Chinese embassy twice and on and on and on. And I made a large sign, "Thank you, Suzanne," which we unrolled on Tiananmen Square. It was the first time a thank you almost became an international incident as the Chinese police descended on us thinking we were protesting who knows what. So we won't have any international incidents today, but thank you, Professor Percival and staff, and thank you, panelists, Professor Kirk, Professor Mintz, Attorney General Wolfson, Professor Wang, and Dean Paddock for your wonderful remarks. We will be having breakout sessions after the break, and you can find the room locations in your program. So again, thank you, panelists, and thank you, audience, for being so attentive.
It's so, that line of music is so relevant.